The following opinions are expressed solely by Abysmii and do not necessarily reflect the views held by anyone else on this channel. Additional disclaimer: I am not a lawyer. Nothing I say is intended as or should be interpreted as legal advice. Everything I address in this episode is United States law and is freely available online. If you have any questions regarding interpretations of these laws, consult a lawyer. I wanted to get this episode out because of the recent situation between Michael Leroy of the Bad Creepypasta segment on the channel of the same name. While that disagreement has mostly resolved itself, there are still points I'd like to address. Slimebeast has also uploaded a video addressing all this, and I encourage you to watch that for an additional perspective on these topics. I'm going to explain, with my limited legal knowledge, copyright, fair use, and how they pertain to narrators. Copyright, like all intellectual property, is a right. It's in the name for a reason. The legal definition, according to Title 17 of the United States Code, Section 102, subsection A, reads as follows. Copyright protection subsists in accordance with this title in original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Works of authorship include the following categories: literary works, musical works including any accompanying words, dramatic works including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. This is all legalese, of course, but let's focus on a very important clause. Original works of authorship fixed in any tangible medium of expression. Basically, if you translate your idea into a story, or drawing, or song, the minute it becomes ink on paper, paint on canvas, or sounds on an MP3, it is in a tangible format and it is your property. It has automatic protection against any copies being made. Websites, dance moves, recipes, these all have copyright protection if you are the creator and you make it into something that can be expressed and something that can be copied. Why is this important? Because of the very common fallacy known as, if it's on the internet, it's free. It sounds dumb saying it out loud, but a lot of people genuinely think this. People steal art for tattoos without paying or getting permission from the original artist. People use entire songs and videos without getting the rights. And some narrators use stories they don't have permission for. So, never assume you can use whatever you want if it's on the internet. It belongs to someone else unless it is licensed in a certain way. This is where things get tricky. One way to use copyrighted content legally is if the original work falls under a Creative Commons license. For instance, my free ambient music is licensed CC by SA. CC stands for Creative Commons. By means you have to attribute or credit me in your derivative work so people know where to find me. And SA means share alike. Share alike just means that if you transform my songs at all, you have to release your new song also under CC by SA, so it is still free for others to use. Just using my songs in the background of a video is fine, and that video is still your work, but you do have to credit me regardless. CC by SA license means you can use my songs or anything else under that license in commercial works without paying a royalty. However, not all Creative Commons licenses let you use works for profit. Another common license is CC by NC. NC stands for non-commercial, meaning you can use the work as long as you credit the author, but you can't use it in anything that would make you money. A lot of stories and pictures are licensed this way. It allows for public use of the work, but it remains free for everyone. Narrators tend to overlook this license and often get in trouble for monetizing a story that is licensed non-commercial. Don't fall into that trap. Also, these are not exhaustive combinations. There's CC by and CSA, there's CC by. I encourage you to go to the Creative Commons website and look up all of them to educate yourself. Another option is public domain. These are completely free to use, no credit required, no limitations on remixes, and you can do it for profit. A lot of old stories, movies, and sounds are in the public domain as their copyrights have lapsed, meaning the creators are deceased and have not registered their works or have not renewed their copyrights. A lot of new works are also given up to the public domain freely, so keep an eye out for them. The last thing I'm going to say on copyright is about registering with the Copyright Office. As I said previously, you own your works the second you put them into a tangible format. This is a natural right enshrined in US law and it is automatic. You can even use the copyright symbol or notice on your original works without needing to register. You can read about that from a Copyright Office brochure linked in the description below. So, why bother registering? It offers additional protections for your creations. If they are on file with a Copyright Office, you can more easily dispute claims and fight content theft with a special number given to your work. So, why not register all of your works? Because it is expensive, complicated, and time-consuming. I wish there was an easier way for creators to use the federal system, but here's hoping. I can't tell you when and what to register, so it's best to talk to a lawyer. However, be aware that some people will ask to see proof of your copyright, often saying that without the registration that you don't own your work. I get around this by uploading my songs to 4 different websites on the same day they are released. This creates a traceable and permanent log of the first time a song is shared with the internet. If your work is only on one site, it risks being uploaded elsewhere, and you'll have a harder time fighting against theft. If at least one, preferably multiple, sites have a clear designation of your work's status, be it copyrighted fully, CC by SA, or whatever, you will be better able to prove ownership of your work. Authors, this means having a personal website or obvious portfolio somewhere on the internet. Self-publishing on Amazon is another option. You may be asking how derivative works fit into all of this. Derivative works, although based on other copyrighted content, also belong to whomever created the derivative work. But this is where things become very, very tricky. If you talk into a camera about a movie you saw, that review is your work. You were reviewing someone else's work, but you own your ideas as made tangible into a video. However, if you re-upload the entire movie and just talk over it, that's mostly the original work and only a little bit of yours. Similarly, if you recite word for word someone else's story, that is not entirely your original work, and is especially illegal if the story is under a restrictive copyright. This is where fair use comes in. Fair use, as defined by Title 17 of the United States Code, Section 107, is as follows. Notwithstanding the provisions of Sections 106 and 106A, the fair use of a copyrighted work, including such use by reproduction in copies or phonorecords or by any other means specified by that section for purposes such as criticism, comment, news reporting, teaching including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is of fair use, the factors be considered shall include 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole, and 4. The effect of the use upon the potential market for or value of the copyrighted work. The fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. This is a short entry, so please read it multiple times, but I will break down as much as I can. The fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. Basically, if you are using someone else's work to critique it, review it, comment on it, use it to teach others, if you are a news journalist and want to report on it, or just for research and schoolwork, is not an infringement of copyright per se. All of that may fall under fair use. For instance, I am using this website's page to educate people on what I read fair use as. It may qualify as a fair use treatment. This next sentence and subsections are incredibly important. To paraphrase, in determining whether a work using another work qualifies as fair use, the following requirements will be considered. I'm going to state very plainly right now, fair use is not a right. It is not a copyright. It is a legal defense. Meaning, if the original creator claims you violated their copyright by using an original work, you can defend your derivative work by asserting fair use. However, that does not mean you automatically are protected. It means you have to prove your work is in fact fair use. How do you prove that? With the following categories. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Are you using the work just to make money? Are you using it in a school? 2. The nature of the copyrighted work. Is the original work in the public domain? Is it an older work? Is it very personal or very public? 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. Did you use a couple clips of the movie, or did you re-upload the entire thing and talk over it? 4. The effect of the use upon the potential market for or value of the copyrighted work. Is your video driving people away from seeing the movie and paying for it? The fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. I'm actually not comfortable talking about this one because I don't think my interpretation of it is completely correct or fully informed. Please consult a lawyer if you have any questions. To summarize, if you use someone else's work as the basis of your work, also called a derivative work, you will only succeed on a fair use claim if you satisfy some or all of the criteria. Keep in mind, only legal authorities can make an official determination. YouTube may think something is or isn't fair use, but they can't legally say as they are not a judge or a courtroom. Be careful how much you use in your reviews, let's plays, narrations, etc. It's always best to err on the side of your original work instead of using someone else's. Now, a term you may have heard of is transformative. A lot of people consider this the same thing as derivative, but it is actually a subset of derivative. A transformative work as defined by the Copyright Office website is as follows. Transformative uses are those that add something new with a further purpose or different character and do not substitute for the original use of the work. As an example, you take an MP3 of a song. You slow it down, reverse it, chop it up, and set it to your own drum pattern. The original song is almost completely unrecognizable at that point, because you transformed it into something new, versus a derivative work where you would play the song in its original format and just talk about it. If it hasn't become apparent, derivative works, transformative works, and fair use are gray areas. They are not obvious and not consistent. The Copyright Office states that fair use is a legal doctrine that promotes freedom of expression by permitting the unlicensed use of protected works in certain circumstances. Fair use is done on a case-by-case basis. This means what someone else gets away with does not automatically mean you can get away with it too. Another issue is that there is not a lot of case law on fair use as it pertains to YouTube. That means we can't look at a case and confidently state, oh, the court said Let's Plays are fair use. Even if cases like this existed, the fair use doctrine is intentionally broad as pointed out by the University of Santa Barbara. Not all works and situations are the same, so the courts probably want to keep everything on that case-by-case basis. If I haven't bored you to death with legal code yet, then thanks for sticking with me. I'm now going to tie all this back into narrations on YouTube. I put a fair use disclaimer on the Raw Dog Readings episodes. I do this because I believe our method of reading a story blind with lots of pauses, tangents, and criticism with random bits of music and images as a derivative work is transformative enough to qualify as fair use. Someone listening to our episodes is going to hear the story read in a very piecemeal way, with commentary and criticism. What takes someone 5 minutes to read takes us an hour. Hell, sometimes I intentionally read the sentences differently. I think we are being transformative and I think we own our reviews. However, I fully admit that I may be wrong. A court could very well decide that what I'm doing is not transformative enough. In fact, I'm more likely to take down an episode if an author asks me and explains why they don't want their work being used in such a way. Because I respect authors and I'm not making any money off these reviews. Without the authors, these critique shows would not exist. Compare that to the average narration. Narrators recite the stories word for word. Nothing added, nothing removed, nothing about the story changed, usually. They are using a script that someone else wrote and owns. This does not transform the original story, it is simply derivative. Narrators often make the argument that adding music and images might be transformative and that turning the written word into spoken word is different enough. They will probably lose that argument. Why? Because they aren't changing the story or commenting on it. They are creating a work that on the whole is barely different than the original. If you don't believe me, ask yourself this. Why don't narrators use Stephen King stories? If their videos are so transformative, why not read popular published books? It's because that argument is simply weak and most likely would not convince a judge, in my opinion. I don't read copyrighted published works very often on Raw Dog or Raygun because I simply don't know how it would stand up in court. Using stories that are often CC by SA or so old that they are likely in the public domain is safer. And yet, some narrators will put a fair use disclaimer on their videos. Then they complain about DMCAs as if fair use is 100% guaranteed. It simply isn't. Especially if you aren't changing anything and just reciting other people's stories word for word without anything else added. Michael Leroy may very well be correct that his bad creepypasta show qualifies as fair use, but he also could be entirely wrong. Getting a strike sustained or dismissed from YouTube is not a legal determination. YouTube is not a courtroom. Do not rely on what happens to other channels and authors to dictate whether or not your work is fair use or if someone else's video is infringing on your copyright. You can state your claim, but unless a judge says otherwise, we just don't know for sure. The moral of the story is this. I could wake up tomorrow and have both Raw Dog and Ray Gun completely taken down. It would suck, I would defend my work, but more than likely I would submit that the authors made a good case. My podcast exists based on someone else's story, and I think it is greedy and selfish for narrators to assume that what minimal work they are doing is guaranteed protected. I've seen interviews with narrators who are described as the people behind the stories, and it makes me sick. The authors get that accolade, not the narrators. The narrators are simply just doing someone else's story, music, and images to read a script they didn't write. They are doing the bare minimum. Not all narrators, of course. Many are very transformative and put a lot of original work into their videos. But 99% are piggybacking on the authors. I've only had 2 copyright strikes on my music, both of which were false. So I know what it is like to have someone try to take what you have worked hard on. And you know what else? I don't have to worry about stealing from others. The truth is, we need more original content on YouTube. Our collective obsession with derivative works is getting out of hand. That's not to say people shouldn't narrate or derivative works are a bad idea. But if you are a narrator or thinking of becoming a narrator, consider doing something original. If not, read up on fair use, derivative works, transformative works, and copyright. Know what you are getting into. Respect the people who made the content you are using. Don't let the big channels who steal and misuse fair use as examples to follow. And lastly, don't be afraid to speak out against wrongdoings you see happening around you. Thank you for listening. All the original music used here is of my creation. You can check out my music channel if you enjoy that. You can also check out my science fiction podcast, Ray Gun Readers, if you want more story analysis. Thanks again.